Welcome back. You're listening to The Voice of Russia in London. A British man accused of exporting parts for Iranian missiles has made his first appearance in a US court this week. Retired businessman Christopher Tapin was remanded in custody until Friday, when his lawyer said he would vigorously pursue the case for bail. He was extradited to the US last week after a battle through the British courts, and he denies the allegations. His family have said they feel let down by the extradition system and felt motivated by a sense of injustice. Gary Mulgren is another British national extradited to face trial in the US. As one-third of the NatWest 3, he was convicted in 2006 of wire fraud involving the disgraced US corporate giant Enron. After losing his 2-year battle against extradition in the British courts and at the European Court of Human Rights, he was flown to the US, where he was sentenced to 37 months in prison. I asked him about his experience.
The moment when you get on that plane and your own country has allowed another country to come in and basically destroy your life. I was a single father with a 10-year-old son and a 5-year-old daughter, and I'd had to sit down and tell them that I was leaving. And at the time, the US had threatened me with a sentence of up to 35 years. That's one of their key tactics, is to intimidate you by the length of the sentence. I knew when I got on that plane, I felt completely bereft. I felt very betrayed by my own country. I was very, very uncertain about what I faced in Texas. I had very little hope that I would be able to get witnesses from England, get the information I needed from England to put on a fair trial. Additionally, in America, the system operates that your legal expenses, even if you win, you never get the money back. So I was facing bankruptcy, and automatically, before being determined innocent or guilty, my life was completely destroyed, and my children's life was hammered. No parent should ever have to tell their 10-year-old son that they're leaving them and they don't know when they're coming back.
To continue the issue of extradition, I'm joined in the studio by Robert Henoch, a lawyer at the American law firm Cobra & Kim, specialising in extradition, Emily Smith from Fair Trials International, a charity campaigning for people's rights to fair trial abroad. Also in the studio is Fadi Daoud, a British lawyer and specialist on extradition working in the UK. And on the line we have Nadezhda Omarleva, an extradition specialist for the Russian law firm Musayev and Partners in Moscow. In your own professional opinions, having heard from Gary Mulgren earlier and his experience of extradition to the US, along with the ongoing case of Christopher Tapin, do you think the current system is fair?
That's a huge question.
It certainly is.
The situation is this. Let me just go to very much the basic sort of situation with extradition. What we're talking about here is the movement of people who are either suspected of committing criminal offences or have indeed committed criminal offences and need to be taken from one country to another so that they can spend some time in prison, for example, so they can do the custodial element of perhaps a sentence that they'd received. So the first part is, the reason we extradite people is because they're wanted by by another country, and it's a formal process of removing that person from this jurisdiction to another jurisdiction. That is the basis of extradition. There are two ways you can do it in a nutshell. Either use royal prerogative, and that's very much on an agreement between two different states. For example, here in Somalia, there's no formal method of extraditing people from Somalia. We'll contact the Somali authorities. We would like this particular person to come back. Can we please have him back? And there will be then negotiations between the governments to have that person removed from Somalia and brought to the UK. The other way, which is the majority of people who are extradited, both in and out, would be formal agreements that are then regulated by a local statute, which is the Extradition Act, and that may come because there's agreements between us and America, for example, or because there is a European framework decision that's between European countries, so for example between us and other EU countries. So that would be how that would work, and it's a very formal process that you'd go through with the Extradition Act.
Well, there's an assumption that, particularly based on the Christopher Tapin case, where his wife and his legal representative has said that the system is heavily weighted in favour of the US. Is this the case?
Well, the standards of proof and the quantity of evidence that is required from the United States and the United Kingdom are different. So there is, without a doubt, a disparity, and there's really no reason to even debate that. So I think the question becomes, why is there a disparity? And the reason from an American perspective is that the United States Justice Department and the 50 other jurisdictions, the 50 states of the Union that prosecute crime, do not want to have a higher standard of proof imposed upon them than is required in a normal arrest context in the United States for people that they are seeking who happen to be overseas. The other concern from the U.S. perspective is, frankly, one of discovery. U.S. prosecutors and state prosecutors and attorneys general want to hold on to the evidence as long as they can and not disclose it to the defendant, because that's, in fact, the U.S. tradition, that it does not, the evidence and the discovery does not have to be turned over until a much later stage in the proceeding. And the concern is, why would we give an unfair advantage to someone who just happens to be residing in another jurisdiction? I think where the controversy comes in, and Mr. Tappan's case is a good example of it, is when, and the NatWest 3 is obviously an outstanding example of it, is when the conduct which is occurring is taking place entirely in the United Kingdom. And the United States authorities and the state authorities are left with arguing, well, it impacts on the United States somehow, therefore we have a right to extradition, and we're going to exercise that right. And the other issues that come in is, frankly, the United States methodology in terms of investigations and prosecutions is a much more aggressive methodology than what's used in the United Kingdom. And frankly, what does not offend Americans frequently is offensive in the United Kingdom. So that's where I think a lot of the issues lie and where it gets quite thorny, because I don't think putting the United States in the category of Turkey and Romania and Albania, which is what the treaty does in terms of the quantum of evidence that's required, is where the discussion ends. The point is that the United States is far and away the most aggressive prosecutorial machine and investigative machine in the world. The United Kingdom has arguably ceded control and of the regulation of the financial markets to the United States, when said to the United States taxpayers, you can pay the burden for this and we're not going to pay the burden. So that's part of what's going on here, is that the U.S. is very aggressive. They're very aggressive in asserting long-arm jurisdiction, meaning United States government officials believe that they have jurisdiction over people who aren't in their country for any actions that arguably impact on America. And they've taken an extremely aggressive stance on what constitutes conduct that impacts on the United States of America via the various statutes. And we've seen a lot of recent cases where that's actually blown up on the U.S. Justice Department.
Can I just... I think that's sort of a key point there, is that the US is quite aggressive in the prosecutions that it goes for. And what we've got to be careful not to forget when talking about this is, I would absolutely agree that, with cross-border crime increasing, becoming more sophisticated, cybercrime, human trafficking, etc. So yes, I think it is absolutely important that you have jurisdictions that are able and willing to prosecute cross-border crime, particularly as it becomes more sophisticated. But I think what we've got to not lose sight of, and the cases of people like Christopher Tappin, people like Gary McKinnon, bring to light, is the enormous human impact that extradition has. That when you've got offences that are committed wholly outside of the country, don't necessarily even use US servers, in the case of Richard O'Dwyer, another person subject to extradition to the US, that the huge impact it has on that person to be taken away from their family, and we heard from Gary Muldrew earlier, to be taken away from their family, from their children, to be put into a foreign criminal justice system where they may not know anyone, their family may be unable to visit them, that's something that really does need to be taken into account, and that so often isn't in a fight for sort of combating cross-border crime.
And just to remind you, you're listening to The Voice of Russia in London, and today we're discussing extradition.
Can I just come back on something that was mentioned earlier about the aggressive prosecutions? Now, I'm just going to give a bit of a contrary view on the position between us and the US. it's quite clear that the US is much more aggressive about prosecuting those outside its geographical borders. So that there is that frightening element to it. But to say that the two tests are different, I'm just going to say, well, the two tests are these, so that we're aware of them. The US test is probable cause, and our test that needs to be satisfied here is reasonable suspicion. Now, I'm just going to read out just a little extract, perhaps, if you'd let me, from the Scott Baker report. And I'm going to just go to the absolute nutshell, as it were. 1.21, in our opinion, there is no significant difference between the probable cause test and the reasonable suspicion test. Now, that's a long review that was conducted by Scott Baker. It went into a considerable amount of detail, and it heard a lot of evidence from individuals. So the actual, because there are different phrases being used, the net result is actually probably the same, in that all you need to do is show that there is some evidence of criminality, and if there is something, therefore, to put before the court, then that is sufficient. Now, if you compare that with how we were before the Act came into play on the 1st of January 2004, you needed to get much more evidence together.
From a Russian perspective, we mentioned the case of Alexander Litvinenko, the former KGB operative killed in London in 2006. This is perhaps a mixture of extradition and politics. Can you explain what the difference is there between Russia and the UK and their extradition policies?
As far as the case of Alexander Litvinenko and the possible prospective extradition of the person who is accused or suspected of committing this crime, I can mention that in case he is a Russian national and he is at the moment on the territory of Russia, he can never be extradited to any other countries, and including the United Kingdom, as far as it's a constitutional guarantee for all the citizens not to be extradited in other countries. Is the first point. The second point, as far as the general extradition policy of Russian Federation is concerned, the main point is that extradition issues are solved by the General Prosecutor's Office, and with an extradition proceedings, the Prosecutor's Office does not touch the questions of guilt or innocence of one whose extradition is requested. The extradition is mainly focused on whether the extradition request meets formal grounds, formal criterions established by Russian Criminal Code of Procedure, and whether it is, and if it is so, the extradition request is satisfied and a person is extradited. The problem is that Russian Criminal Code of Procedure does not take into account human rights issues, which are very sensitive in the questions of extradition, as far as the person is put under risk of grave human rights violations.
And just to remind you, you're listening to The Voice of Russia in London, and today we're discussing extradition. You mentioned earlier that Russia does not allow extradition for its citizens to face trial abroad.
We have a tradition in the UK, England and Wales in particular, but a tradition here that you will not differentiate usually between nationalities. It is the individual who is facing a criminal trial, an allegation. It is nothing to do with where they come from. And the idea that justice has to be blind, I mean, it is entrenched, back to the 1700s, I think 1600s, that there are cases that refer to you can't look at the difference of somebody's skin colour, etc. Either they're guilty or they're not guilty on the evidence. And that's been a tradition that's applied. And so most legislation, other than sort of immigration-type legislation, does really not differentiate at all on nationality in the UK generally.
I was actually going to go back to another comment that Nadija made about the lack of the human rights requirement in Russian law, and just to make the comment that the UK does in theory require courts to consider human rights before extraditing someone, and not to extradite if their human rights will be breached. but it has been very difficult, and it's a very high threshold, actually, even where that legislation does exist, to get courts to rule on that. And we do see cases where very, very good arguments are made about the situation in the requesting state, the state that the person's going to be sent to, about the conditions they will be held in, or the sort of trial they might face, and particularly within Europe, but also for the rest of the world, the courts are very, very unwilling to find against either friendly countries or fellow EU member states, and to hold that there are human rights problems there. And we do quite often get cases equally from the UK going to the European Court of Human Rights on this basis to try and stop extradition. That's something that we've tried to get courts to look at more, and they are increasingly willing to, but it's been a long battle.
And that's something that Gary Mulgren mentioned earlier today, that when he was extradited from the UK to the US, unlike Christopher Tappin, who apparently is in solitary confinement in one cell, Gary was thrown into a cell with 80 other inmates. He said that this was the norm. Is that the case? I mean, is that a human rights issue?
Whether it's a human rights issue is a matter for the UK, the English courts to decide. I wouldn't really want to comment on that. There is a prison system in America that is widely varied from jurisdiction to jurisdiction. Some of the prisons have very difficult conditions, and some much less so. I think one key aspect of this entire debate that Mr. Tappin's case raises particularly is why is it that the United Kingdom allowed him to be extradited as opposed to prosecuting him themselves? The United Kingdom has laws on its books since 2004 which restrict dealings with Iran. The United Kingdom could have brought a prosecution. He would have then been assured all of the protections that are consistent with English tradition and English law, and he could have been prosecuted here. Now, why is it that the United Kingdom and the leadership in this country is ceding to the United States the authority to enforce English law? Because if you look at all of these cases, they are all arguably cases where there is dual criminality. I don't think there was a particularly strong argument in any of these cases we've cited that the crime in question, that the conduct in question was criminal in one jurisdiction and not criminal in another. So what I would think one very smart solution would be if the United States executive branch and the decision makers in the prosecutor's arm and the Justice Ministry here in the United Kingdom got together and decided we're going to equally enforce the law, and if we see that the Americans have made a case that we can live with, we'll prosecute it here. And you Americans can come over here and participate in it, and we'll do the case here. You have now a lethargic, pardon me, I know I'm sitting in England, a lethargic regulatory and enforcement regime in this country. That's just a fact. There's really nobody who would argue credibly to the contrary in comparison with the United States. So given that set of facts, and given that the United States and the U.S. taxpayers are funding the oversight of the financial markets, which benefits the entire free world and large portions of the unfree world, that's part of the problem. That's part of the issue here. The UK is not devoting the resources to combating financial and other crime, including crimes that are on its books in terms of dealing with Iran, that the United States is. And that is, in essence, ceding much of this territory to America that shouldn't be ceded.
I don't think it's a question of ceding to America. I think it's because we have a very different attitude towards prosecuting. Our attitude is, although we have a similar sort of common law system, the actual attitude towards prosecutions and crime generally is that there is a discretion that is applied by our prosecuting authorities. You don't go all out to prosecute everything you possibly can. And this is one of the fundamentals that we have here. Yes, you can be naughty, and we'll have a look at it and we'll see if it's in the interests of justice or not to actually prosecute someone. So we start off with, we shouldn't be prosecuting everyone, but if we do want to, we're going to. I think that there is a fundamental... The reason why there is such difficulty between us and other jurisdictions, I think that there is this perception that our citizens are being treated unfairly. Prison conditions, as Emily has mentioned earlier on, both in the US and also in other European countries, where there's no heat on in some of the prisons, for example. You don't get medical treatment as well. Solitary confinement. You've got is it the Supermax, I think they're called in the US?
There's one Supermax prison.
Which, for us, there is absolutely no way we're going to be housing people in this way in the UK. We just don't do it. We have quite clearly decided that extradition is a good thing, that we need to have it. We have watered down what would stop somebody being extradited following 9/11, because at the time it was believed, look, we have to start moving people around quicker because we needed alleged terrorists to come back from Italy at the time.
But is that at the expense of legality? Because there's a lot of, particularly in the immediate aftermath of 9/11, the Bush administration openly admitted to extrajudicial rendition.
That's something that I think the US needs to answer. But for us here, it is not at the expense of legality. It is at the expense of... We have basically reduced the difficulties and the obstacles in extradition. That's what we've tried to do, to make it a smoother and easier process. Because what we say is, well, look, do we trust our American brothers? Answer, of course we do. They've got a similar system to us. They may apply it slightly differently, but we trust them. Do we trust our fellow Europeans? Of course we do. They just do things slightly differently, but that doesn't mean we can't trust them. The French have always had their investigatory system. As an example, the Poles have never had any discretion as far as a judge is concerned as to whether or not they will or will not prosecute someone. They will prosecute someone and they will have them back for, and these are true matters of, theft of a pig, wardrobe doors, very, very minor theft from a petrol station, for example. These are very minor offences. There is no triviality test, and this is the test we used to have pre the 2003 Act. We don't have that anymore. So there is that element of it, that people are just being extradited for any old thing, and that's why there's been, I think, it's about 1,300 or 1,400 extraditions now every year back to the European Union, for example. So there has been that element. I know Emily wants to get in, so...
I can completely agree with everything that Fadi has just said, but also in sort of answer to your question, do you think that's been at the expense of legality? Maybe not at the expense of legality, but certainly, and this is following on from Fadi, it has been at the expense of defence rights, of the human rights of the people being extradited, that there's... there is obviously a need to have extradition processes in place, and I don't think anyone would argue that we don't need them, they don't need to be effective, and that there are serious cross-border crimes that need to be addressed. But that it's very important to have safeguards in place to make sure that people being extradited are also protected, and that they're not that those safeguards are in place, and that perhaps has been lost.
Can I just come back on that point, Robert? Sorry, before you... Just the one thing that Emily has said is about the human rights. That's something I didn't touch on. The human rights tests, the bars to human rights are very, very high. So the tests would usually be a fair trial, inhumane or degrading treatment. They're the sort of classic arguments you'd be running, and right to family life. So these arguments... to stop somebody being extradited are very high hurdles for the person who's being extradited to show and to meet. This is the problem that you face, that if they could be, for example, as a hurdle, reduced so they're not so difficult, then that would, I think, import a bit of humanity into the process. It's not necessarily the lack of human rights per se, it is the lack of humanity from that's been taken out of these sorts of extraditions that have occurred.
An interesting point that's been made off-line is that the United States has almost never refused, I think never refused to extradite someone from the United States to the United Kingdom, whereas the United Kingdom has refused to extradite to the United States. And I think that's an important thing for everybody to keep in mind in light of this very sensitive debate that's going on now.
And unfortunately, that's all we have time for today. Thank you to all my guests: Robert Henoch, a lawyer at the American law firm Cobre & Kim; Emily Smith from Fair Trials International; Fadi Daoud, British lawyer and specialist on extradition working in the UK; and Nadezhda Ermolieva, an extradition specialist for the Russian law firm Musayev & Partners based in Moscow.